Test, test,
Working.
test, test. Yeah, I figured it out. So if we on if it's on unless it's live, you don't hear anything. I've got to figure out a way to be able to hear. How's the sound?
Clear all the rattling that's going on.
Thank you, Mr. Dupuy.
Ladies, before I start with the main of our argument, you asked me about comment at page 235 in the appeal decision yesterday. Maybe I just said the third appellant's appeal is concerned with the impact of the seismic pulse on marine mammals, to my comments in relation thereto. Appellants, in example where it is discussed, it's not section 31, and that's the DFFE minister, minister's answering affidavit.
Thank you.
Paragraph 31.4, several mitigation measures have been identified and adopted as specific conditions in the EA and the MPR, which mitigation measures must be applied during all phases of the proposed 3D seismic survey activities. 31.5, as I've already highlighted above and elsewhere in this affidavit, the moment that there are mammals or faunal species, as prescribed at pages 254 to 555 of the BAR, observed within 500 meters of the mitigation zone, or any mortality of marine mammals, the seismic survey activities must cease immediately. 31.6, daily and monthly monitoring of any potential impact on marine life is also included as an express mitigation measure and explicit condition in the EA and the amended EA. 31.7, the BAR included the assumptions and limitations and the knowledge gaps in relation to the impact on the marine environment. It is specifically recorded in the appeal decision that although there are information gaps, the known information has a relatively high level of certainty insofar as the impact predictions in the marine fauna report are concerned. And then 31.8, the limited information further available was mostly obtained during hydrocarbon exploration projects. This means that seismic surveys have a dual purpose: not only obtaining data for hydrocarbon exploration projects, but also providing an opportunity to collect baseline environmental data at depths beyond which commercial fisheries operates. And lady, if I might take you to the relevant portions at page 5 to 6. Your ladyship will see at the bottom of the page there's paragraph 31.4.1.3.4 shutdowns. This is an example where the condition is that the activity must be terminated when a seismic source on observation and or detection of penguins or feeding aggregation of diving seabirds, turtles, slow swimming large pelagic fish including whale sharks, basking sharks, manta rays or crustaceans within the 500-meter mitigation zone, and then it continues up to 11.4.1.3. I'm not going to read it, but it is there. Then also at page 200, ladyship will see that this recommendation has been accepted and implemented in the EA. Page 200, especially paragraph 5.4.1. MPR is hereby approved. It is hence mandatory for the holder to implement all the recommendations and management measures stipulated in the MPR throughout all phases of operation, and any non-compliance with this authorization may result 49A of NEA. At page 205, the Minister has an assessment of potential impacts are aligned that the planned activities will not result in any detrimental. 2 and April 2022 served before the DG and included in the EAP, but now on did not serve before the DG or the Minister, and they subsequently could not have considered them. My lady, we've had to spend hours to answer to those allegations, only to be abandoned and focused on that these reports shows that there are gaps that the Minister should have considered. My lady, once again, that is nothing else, even on that argument, as an appeal in disguise, because ladyship is reviews marine studies, whilst Dr. Harris only refers to 38. And there is no reason why the DG or the Minister should abandon their own analysis of these studies just because the applicants differ from that proposition. lady, if one reads Dr. Forney's report, she's actually criticizing the BAR. And it is not a project-specific analysis of the TGS project. Armchair criticism after the fact. And we submit that the DG and the Minister were entitled to accept the experts who conducted the original analysis in respect of the project instead of armchair criticism. As far as the precautionary rule is concerned, the BAR acknowledges these gaps, but as I've already argued that the precautionary rule does not require complete prohibition of proposed activity. No activity is not an option. The principle imposes a burden of demonstrating no unacceptable harm, not a permanent bar to development. And my lady, as we've already indicated, this whole decision centers around the polycentric nature of the decision. You have different inputs weighing up balances and factors, weighing up and balancing factors and considerations. And that is what the DG and the Minister did. Courts must be sensitive to the legitimate constitutional democratic functions of the executive. It should not interfere with the exercise of their discretion in this regard. We submit that as far as the Pajak grounds are concerned, the applicants have failed to show any cause for the setting aside of my lady, we once again submit that this is an appeal in disguise because the applicants disagree with the reasoning and conclusion of the appeal. Now, the other seismic surveys require each their own EAs. And even if the EIs were granted, it does not mean that there will be a cumulative impact because we don't know whether they will be conducted simultaneously. We don't know what the extent of the other surveys will be. But that is irrelevant for purposes of this discussion because we are focusing on the current EA and in any event the precautionary rule does not prohibit the decision. Section 2.4 of NEMA requires a risk-averse and cautious approach that takes into account the limits of current knowledge, including by using conservative assumptions and mitigation, rather than refusing any activities whenever any scientific uncertainty exists, and that's what the fuel retailers case said. Now, my lady, the conclusion was that with mitigation measures, even if the surveys are conducted simultaneously, will be low. Milady, once again we submit that there is nothing irregular in that decision that warrants a POJA application and decision on POJA. Our next ground is public participation allegations, and we deal with that as the second ground of review in our heads of argument. Now, initially, the applicants advanced a standalone and wide-ranging challenge to the adequacy and fairness of the entire public participation process. But the Minister and the DG dispelled this in their answering affidavits, and may I refer you specifically to paragraphs 44.5 at page 4242. Of the answering affidavit. The applicants have now abandoned this, save for two specific plans. Shipboard oil pollution. Now, 9. Appears at page 521. Your Ladyship will note page 521. Your Ladyship will note that there's a heading 11.4 recommendations for inclusion in environmental authorization, 11.4.1 marine ecology, and then the application of the mitigation hierarchy. In the middle, there are bullet points. The operator will ensure that the proposed seismic survey is undertaken in a manner consistent with good international industry practice and compliance with the applicable requirements in MARPOL, as summarized below. The discharge of biodegradable waste from vessels is regulated by MARPOL, which stipulates that. Then the next one, discharges by oily water, deck drainage, bilge and mud pit wash residue to the marine environment are regulated by MARPOL 73. The next bullet point, sewage and grey water discharges from vessels, and we can continue, my lady. Now, my lady, these pertain to the small vessel, the vessel that's going to draw the seismic survey apparatus. They are applicable to all vessels, irrespective whether it's a fishing vessel or one of the pleasure boats, the V&A. Those are the standard requirements for vessels. They do not pertain to a contingency plan for a well blowout whilst drilling, etc. It does not form part of the activity as such. If we may move inland, lady, if you are going to start mining, the activity is mining. And it is necessary that there must be public participation in that this decision whether to grant the right to mine or not. But how you are going to deal with a TLB breakdown leaking oil is a contingency plan that follows subsequent and as a result of the activity. It is not something that the public needs to address or participate in how that is going to be done. It's an operational aspect, not activity related. Lady, we say that the operational plans do not introduce new activities or alter the scope of the authorized activities. These plans are vessel-specific response procedures, must comply with international conventions, prevents pollution from ships during ordinary operations, and could not have been finalized because the seismic and support vessels have not yet been identified when the EA was granted. The applicants conflate the assessment of environmental risks associated with the authorized activity with subsequent operational implementation. The lady, as far as the applicants rely on the green connection for their argument that there must be public participation in these plans, we submit that green connection is not authority for that proposition, and it's in any event unsustainable. My learned friends handed up to your ladyship this morning a bundle of their authority that they rely on. Lady, if I may take you to page 150 of their authority. Lady, it's also in our bundle, but page 150.
I'm just trying to identify what this is.
It is the
It's a
green
green
connection.
Okay.
Okay.
150.
Yes, it starts at paragraph 190. The fifth ground is a challenge to the Environmental Management Program in EMPR for the proposed project on the following basis. Firstly, that the blowout contingency plan and oil spill contingency plan were not made available when the final EIR was prepared and when the decisions under review were taken. Secondly, that the blowout contingency plan and the oil spill contingency plan documents were required to form part of the EMPR for the proposed project because they are documents which will describe how Total intends to modify, remedy, control or stop an oil spill resulting from a well blowout. Thirdly, the process through which the final EIR and the EMPR were prepared and through which the EA was granted was not procedurally fair and did not comply with the public participation requirements in NEMA. So it pertains to the contingency plans for blowouts and oil spills, not the small vessels that they are attacking now. My lady, but in footnote 94, the bottom of the page. The condition of the EA reads, and it's similar to the one that we are confronted now with. The holder must, within 60 days prior to the commencement of the proposed drilling operations, submit all specific management plans identified in the final EIR, i.e. the shipboard oil pollution emergency plan, the small vessel plan that they are complaining now about, emergency response blowout contingency plan, the plan that they are complaining about now, And then the oil spill contingency plan, stakeholders engagement plan, waste emission discharge management plan, etc. So, my lady, in that case, there was the same proposition that these plans must be submitted 60 days after the commencement of the proposed drilling operations, and they did not have a problem with them at that stage. And the judgment in respect of ring connection was not based on an attack on these two plans. These like that pertaining to the vessel. The applicants want to equate project-specific blowout contingency planning associated with offshore drilling with standard routine maritime operational planning and emergency response measures applicable to offshore vessels in general. And there is no requirement that there must be any public participation or investigation in this regard. Neither NEMA nor the EIA regulations require public participation in every implementation-oriented operational management plan contemplated by an EA. And therefore we say that there is no ground, no merit in this ground, and that it should also be dismissed. And, my lady, we've already demonstrated that these plans and the implementation thereof, all these aspects were covered in the barring in. Lady, and that I suppose covers all the grounds of review. What remains is to deal with the delegation aspect, which was abandoned at this very late stage, my lady. It was a huge point in dispute for the parties, between the parties and before the court. We had to spend a lot of time preparing for it, addressing it, and it was in effect only raised during in the replying affidavit. We submit that in that regard the lot of unnecessary cost and time to spend on a moot point. And the same applies to the public participation aspect. Lady, then the applicants ask that the decisions be set aside, but nothing more. Well, in the notice of motion, they also ask that the court substitutes the decision with the court, but that has also been abandoned, causing also a lot of preparation and answering to a very difficult founding affidavit to answer to because of the plethora of allegations scattered amongst a plethora of paragraphs and contentions. But as your ladyship correctly indicated, setting aside the decisions will not dispose of the application. The application will still be there, and something must happen with that application. Now, as we see it, there are only three options. The first is, and that is we submit, is the correct approach is to dismiss the application.
This one.
Or secondly, set aside the decisions on the specific points that your ladyship will find or may find need to be addressed. But my lady, we say that is not necessary, it should be dismissed. And then lastly, to set aside the decisions and to replace it with the court's own decision. But we submit that under the circumstances and having regard to the very technical nature of the decisions and the polycentric regime that governs decisions like this, that will be inappropriate, but we will ask for the dismissal of the application, which brings us to the question of costs. My lady, may we submit that although the public when there is total abuse of the processes by bringing unfounded, unwarranted, meritless applications, which do not only cause the delay of the implementation of the activity to the detriment of all the communities in South Africa and the development, social economic development of South Africa, but which also cause offend applications like these ones. Cost of two counsel. Thank you. I don't know whether there's anything else you like.
There was just one thing I wanted to have a quick look at, but I just need to find it, if you just bear with me. It's just something that occurred to me when we were going through the mitigation measures that you referred me to. I just need to put my finger on it.
Refer to page.
It's here. I think it's in the BAR. It may be of no moment, but I just want to check while I still have the opportunity to
Lady, I referred you to page 5 to 6
have a look at, see if it's 5
and
to
200
6.
and 205.
Yeah. It was something to do with in the event of conditions changing as one of the conditions, the mitigation conditions. Probably not putting that very well, but 205. Have a look. Oh yes, it was just, that's right. Page 200, 5.4.3, one of the conditions, requirements, and all recommendations and management measures, any non-competence in the operation and management of the authorized to the and additional changes, you've got to come back again.
That's correct, Lady. They can't
Management. So either, as I understand it, inherent activity, the operation.
Lady, activities do not pertain to the authorized activities. It's the operation and management of the authorized activities. Then, in addition to
answered my
that,
query.
you have the operational.
Mr. Bradwell?
I have two documents that I would like to hand up.
Thank you.
First is the order of the SCA in relation to the matters that we discussed.
Okay.
And the second is the typescript of the argument that I'm going to present so that you do not have to take notes, and copies will be distributed to
Thank you.
the other people in the court with your leave. While my colleague is attending to that, could I just briefly refer to the order?
Yes.
So the order appears on the second page.
I had a sudden panic there. I wondered I wasn't party to this when I was there, but I'm relieved to see I wasn't. Okay.
I think Judge Unterhalter had a memory lapse of that kind when we interviewed once for a position. So there was an application for leave to appeal. That's this petition to add grounds. That's referred for oral argument. Mm-hmm. And the parties must be prepared to address the court on the merits. And if one turns over the page, you will see a similar order is made in relation to another application for leave, this time by the Minister. This one is by Shell. And the upshot is that these matters will be heard together as appeals where leave was granted and applications for leave, but please deal with the merits whether it wasn't granted. So our understanding of the situation is that everything is up for grabs, as it were, in the Green Connection case. Obviously, the successful applicants in that case are entitled to take any points open to them on the papers, also to defend the judgment, even if they weren't accepted by the Court of First Instance. Thank you, milady. Then to my note. The applicants attack the environment authorization which the Director General granted on the 17th of April 2023 to my client TGS to conduct a seismic survey more than 100 kilometers off the west coast of South Africa. And they also attack the dismissal on the 22nd of May 2024 by the Environment Minister of their appeals against the granting of the EA. In their founding and replying papers, they asserted 10 grounds of review and submitted affidavits together with their annexures running to thousands of pages. In their argument, heads of argument, they jettisoned 2 of their grounds of review, including their challenge to the public participation process which preceded the granting of the environmental authorization. Inexplicably, however, they had persisted with those 2 grounds of review in their voluminous replying papers delivered a few days before their heads of argument. And we associate ourselves with the submissions by our learned friends for the state respondents regarding the time and effort it took to deal with what was plainly a baseless attack on the public participation process. As your ladyship will have seen from the papers, there were several public participation processes before the EA was granted, and they were extensive indeed. Now, during their oral argument yesterday, the applicants jettisoned a 3rd ground of review, this one challenging the delegation of first instance decision-making authority by the Minister to the Director General under Section 103 of the MPRDA, and they did so because that, of course, is a separate decision, administrative decision, and on Oude Kraal it stood unless and until set aside and proceedings properly brought for judicial review. Now, that delegation was doubtless one which operated generally, and its setting aside would have had profound consequences for the proper administration of these matters. And so it is fair to assume that if any such review had been brought, quite apart from the issues concerning the merits, the court seized of it would have had to grapple with the just and equitable remedy in circumstances where many matters could be undisturbed by, for instance, an unmitigated retroactive operation of the remedy. The Constitutional Court authorities are plain that the default position is prospective only, even to the extent where, for instance, in Kunjana's case, a successful challenge to a provision in the Drugs Act authorizing a search warrant on the basis of which evidence was obtained and Ms. Kunjana had been charged was held not to be retroactive. She was charged, tried and convicted based on the evidence so obtained because of our highest court's antipathy to upsetting the apple cart. So behind the rather quickly dealt with abandonment of this review, my lady, is a very serious problem which was presented by that. But at any rate, you are spared having to hear us on those issues on both sides, because what remains then are 7 grounds of review. 4 of them are grouped together because they relate in one way or another to the assessment of marine and cumulative environmental impacts of the proposed seismic survey. We shall address each of them in turn, albeit relatively briefly in some instances, given what our colleagues for the state respondents have already submitted. But before doing so, we would outline the context in which this matter arises for our decision. As explained in our heads at page 9, paragraph 8, the third respondent, TGS, is a well-regarded international survey company that has conducted seismic surveys in South Africa and across the world. It's part of a Norwegian group of companies that are world leaders in seismic surveys with more than 40 years' experience in geoscience data. Importantly, neither TGS nor any other company in the group is involved in extracting or producing hydrocarbons. Instead, their focus is on providing data. TGS's parent company complies with the European Union's corporate sustainability standards, publishes annual sustainability reports which demonstrate, amongst other things, the group's commitment to mitigating and avoiding disruptions to marine ecosystems, and has ratified the UN Global Compact, which is the world's largest corporate sustainability initiative. TGS is therefore a leading and experienced company that takes its sustainability and other environmental obligations seriously. As your ladyship knows, it wishes to undertake a seismic survey in what is known as the Orange Basin off South Africa's west coast. The project area measures approximately 57,400 square kilometers. It starts approximately 120 kilometers offshore from St. Helena Bay and ends approximately 230 kilometers to the north offshore from Honderklip Bay. The entire survey will take place over 70 days, including downtime. And we would emphasize the activities which the survey will entail, because this case is essentially about whether a decision permitting that to happen should be reviewed and set aside. They are well described in the environmental authorization at pages 197 to 198, and in short what will happen is the following. The survey vessel it's about 100 meters in length, that vessel by the way, will acquire data by traveling at a speed of between 4 and 6 knots along transect lines within the project area. While doing so, equipment on the vessel will generate low-frequency, low-energy sound pulses just below the ocean surface, which will be directed at the seabed. Each pulse would last between 5 and 30 milliseconds, with the pulse being discharged every 6 to 20 seconds. The vessel will tow hydrophones, or waterproof microphones, 6 to 10 meters below the ocean's surface, which will pick up acoustic signals reflected from the geological interfaces below the seabed and will transmit them to be recorded. The hydrophones will be grouped together in so-called streamers, which will be towed up to 10,000 meters behind the vessel, 25 meters apart from one another. Because the vessel will have restricted maneuverability as it tows the survey gear, it is assisted by up to 2 escort vessels, which will alert proximate vessels to the survey vessel and its limited maneuverability. Between them, the 3 vessels will transport at least 1 fisheries liaison officer, several marine mammal observers, and a passive acoustic monitoring system. The FLO will facilitate communication with fishers and proximate vessels, while the MMOs and PAM will monitor the surrounds for marine fauna and ensure that no seismic sound begins or continues if marine fauna are observed or detected within 500 meters of the survey vessel. The data gathered during the survey will provide information about the ocean and the seabed. It has many uses, and they're listed in the affidavits, including the affidavit of Mr. Shrimpton. But in summary, it will be used to, amongst others, identify the extent of any natural resources, such as natural gas, and in so doing, facilitate possible exploration and possible production. The evidence is also that some of the information may be used for developing renewable energy solutions, and it will also provide general oceanic scientific information and research data in respect of fish. In the light of some of the submissions for the applicants, we emphasize the following. Firstly, TGS is not involved in extracting or producing hydrocarbons. Instead, its focus is solely on providing data. Secondly, the authorized survey activities do not entail drilling or rigs or the transport of hydrocarbons through pipelines or any other related activities or infrastructure. And thirdly, while the authorized survey area is vast, the survey will only take place in a very small portion thereof at any given time, and consequently its associated impacts will be highly localized and in any event occur far off the South African coastline. As everyone is aware, in order to conduct the seismic survey, TGS requires an environmental authorization, which in turn requires a prior environmental impact assessment to be reported on in a basic assessment report, or BAR as it has been called in these proceedings, and this as contemplated in Regulation 19 of the Environmental Impact Assessment Regulations of 2014. The BAR had to set out the environmental outcomes, impacts, and residual risks of the proposed activity. A company called Environmental Impact Management Services, Pty Limited, or EIMS, was appointed as the Registered Environmental Assessment Practitioner, or EAP or EAP, to prepare the BAR. By regulation, EMS had to be independent and have expertise in conducting environmental impact assessments. Importantly, neither its independence nor its expertise is in dispute. The BAR comprises a comprehensive assessment running to more than 300 pages of the proposed survey's activities, outcomes, impacts, and risks. It was informed and accompanied by 5 specialist studies by other independent scientists, all of whom have made affidavits presented by TGS in these proceedings. They include the following 3 reports which are important for the task at hand. The first is an acoustic technical report. We'll call it the acoustic report by Dr. Jonathan Velata Hernandez, who is a PhD in passive acoustics and 22 years experience in underwater acoustics. The second is a biodiversity and ecosystem services assessment report. We'll call that the biodiversity report, prepared by Dr. Andrea Pulfrich, who has a PhD in fisheries biology. And the third is a specialist fisheries assessment. We shall call that the fisheries report, prepared by Ms. Sarah Wilkinson, who has a BSc honours degree and is a registered professional natural scientist. As I've already mentioned, and as appears from our heads at pages 16 to 18, paragraphs 19 to 21, there were extensive and meaningful public participation processes, both before the draft BAR was completed and in relation to the draft BAR. And the applicants have abandoned their challenge to those processes. The court can therefore accept that the present is not one of those cases where interested and affected parties, including the members of the first applicant, were kept in the dark or otherwise excluded from the processes which culminated in the granting of the environmental authorization. The final BAR, which was completed on the 6th of December 2022, reflected the input from the public participation processes, and along with the accompanying expert reports, referred to more than 950 studies and academic articles. The BAR contained detailed analyses in respect of environmental impacts, as well as a range of mitigation measures. The mitigation measures are referred to in the main body of the BAR and in an accompanying environmental management program, which we shall call the EMPR. The BAR reached the following conclusions. In respect of fish, the impacts of the survey will be very limited and localized. More specifically, The scientists reported a mortal injury zone of approximately 30 meters from the sound source, a non-fatal injury zone of between 90 meters to 180 meters from the sound source, and a zone of temporary hearing loss that's approximately 2.9 kilometers from the sound source. It could also cause behavioral disturbances up to 4 kilometers away from the sound source. Because the project area is in the Orange Basin and offshore of the shelf break, that is the submerged offshore ledge of the shallow continental shelf, where the seafloor transitions to the continental slope, the survey will take place away from important oceanic fishing areas and key spawning nursery areas. It's expected that there will be no impact on small-scale fishing or on all but two of the West Coast fishing sectors. The two exceptions are the large pelagic longline and tuna pole line fishing sectors. While there could be some residual impacts on them, the impacts can be mitigated by not allowing survey activities during June and July, when those sectors would be most affected. Although the applicants argue that the ocean provides a livelihood for their members and has done so for generations, which must of course be a reference to the first applicant, not the second and third applicants, we point out the following. The anticipated impact of the seismic survey on fishing off the relevant part of the West Coast will be limited to the residual impacts which I've just described, and they can be mitigated. And as I've already mentioned, the project area is so far offshore that it will have no impact on the small-scale fishing sector and on its associated inshore recruitment and nursery areas. Turning to the applicant's argument that the impugned decisions by the DG and the Minister have the potential to cause significant harm to the environment, that with respect is not supported by the papers before this court, approached as they must be in accordance with the well-established principles governing disputes of fact in motion proceedings. As explained in our heads at pages 22 to 28, paragraph 27, the picture that emerges from the papers is the following. The Director General and the Environment Minister made their decisions based on excellent and comprehensive scientific evidence, compiled in accordance with international best practice, and they imposed numerous conditions of approval that reflected the mitigating measures suggested by the reporting scientists. The scientific evidence shows that while the survey activities will result in some impacts that could be categorized from low to medium, the adverse impacts can be mitigated to reasonable and appropriate levels. With specific regard to marine species and the ecosystems to which they belong, Dr. Pulfrich points out that all potential impacts on marine species were identified, a precautionary approach was advocated, and mitigation measures based on the worst case scenario were proposed, such that the proposed seismic survey is unlikely to have significant detrimental effects on the marine species and ecosystems to which they belong. Now, my lady, what we will ultimately be submitting is that when one has regard to the information in the record, the documentation, the bar, and the other associated studies that were provided to the decision makers, and you compare that with what I'm now going to have to deal with, the applicant's grounds of review, one is unfortunately driven to conclude that we are dealing with applicants who are searching for reasons, often legal technical ones, which do not raise material problems with the process in order to avoid this going ahead. I submit it would not be unkind, as we shall see when I get down into the detail to describe this application as one of nitpicking, not raising material issues. And where material issues are raised, they amount to disagreements, often strongly expressed, with judgment calls made by the decision makers in this polycentric and technical field, in the exercise of the discretion which Parliament has conferred on them, and with respect, not on this court. Would this be a convenient time?
Thank you, Mr. Golden. Yes, thank you. We'll take the 15-minute adjournment.
Watching my clock. Okay, I'll have a look at that now. Thank you. Thank you. Next. You guys like any biltong? Photographed. I believe in speed.
Yeah. But I think it'll be probably a bit slower at the technical.
Yeah.
Yeah.
relates to the minister. This one is specific to the DG. The contention is that the DG did not have the statutorily prescribed documents before him when deciding TGS's application, and consequently failed to consider, and here they are, the bar, the specialist reports, the EMPR, and the comments from INAPs. And you'll recall that this is the ground from INAPs. And you'll recall that this is the ground which is based on the defective Rule 53 record that was provided. And we submit it has no merit for the reasons given there, and for including in their oral argument, we consider the application form, but all the information submitted in support of the EA application. Now, the applicants criticise the DG for deposing to a confirmatory affidavit that confirms the Environment Minister's allegations concerning him, instead of detailing his own involvement in a separate affidavit. But we point out that a similar challenge was dismissed by the SCA in the well-known Kambili fisheries matter at paragraphs 19 to 23. As our colleagues for the state respondents demonstrated yesterday, the respondents' version, their version, is supported by the contemporaneous documents referred to in our heads of argument at paras 51 to 53, including the EA itself, which both refers to the bar, the EMPR, specialist reports, and the results of the public participation process. You'll recall you were taken to Appendix 1 on page 205, listing the documents that were considered, but it contains wording derived from the bar, to which the specialist reports were annexed, and we outline that in our heads. The applicants rely in this regard on the statements of the Constitutional Court in Helen Suzman Foundation about the function of a Rule 53 record, ensuring an equality of arms between the litigants, and that the reviewing court has the documents it needs to do its job properly. In that regard, we point out that the applicants had the documents, all of them that they mentioned before launching the review proceedings, because they're among the annexures to the founding affidavit. And none of the documents is missing from the voluminous papers now at the disposal of this court. In any event, the applicants do not allege that in the ensuing wide appeal, the Environment Minister too did not consider the documents to which they refer. In other words, if, as the applicants allege, the DG indeed failed to consider those documents, that failure was cured by the Environment Minister exercising her wide powers of appeal with all reference to all the relevant documents. And we refer you to a number of authorities, starting with the well-known seminal work by Lawrence Baxter on administrative law at pages 589 to 590, the Slagment case, which is, quote, the relevant portions of which are quoted in our heads at page 37, paragraph 57, and then Minister of Environmental Affairs versus Cinematic 14 at paragraph 35. And it's perhaps as well that I take you just to that particular authority, if you'll bear with me for a moment.
Mr. Breitenbach, I'm not sure I've got your bundle of authorities.
That you're not sure that you have it.
I have the state respondents' bundle of authorities. This morning I saw I had
My lady,
the
I apologize.
applicants.
Here
No,
it
it's fine.
comes.
It's fine, thank you.
You'll just excuse me to sit down so I can just get this up on my system.
Thank you so much.
So the Cinematic 14 case is at page 235 of the bundle, and I would ask you to go to paragraph 35. We don't have the whole case. But His Lordship, Mr. Justice Scott, as I recall, in that matter, said the following. The case is more or less on point. The issue there was whether there was an unlawful subdelegation by the first instance decision maker to someone else, which he refers to as the delegation issue. What his lordship said is, to return to the present case, once it's accepted that the minister properly applied his mind to the respondent's appeal and that the process was both lawful and procedurally fair, I can think of no reason why any shortcoming in relation to the delegation issue, which in my view wasn't established, should not have been cured by the appeal. There can be no question of the former tainting the latter. And so on, and so it continues. And Lady, we would emphasize that in the light of the affidavit evidence of the Environment Minister confirmed by the DG, that the DG considered all information submitted in support of the application, you have to make a finding of fact to sustain this ground, which is antithetical to that. In other words, you will have to find that the DG lied. And such a finding is not easily made on motion and can really only be made where someone's version is so far-fetched or clearly untenable as to not be worthy of credence. And the biggest problem that the applicants face in this connection, as my learned friends for the state explained yesterday, is that the document signed by the decision maker itself is replete with references to all of the documents which were supposedly not considered. And then, of course, even if they're right, they run into the cinematic 14 problem. That brings us to the second round of review. And Melody, may I just pause here? I spoke about nitpicking before the tea adjournment. A good example of nitpicking is where you take a point which doesn't matter because when one has regard to the entire process, the problem of which you're complaining is cured. So that's a nitpicking point, because they do not say that the minister didn't have everything. And it's not reasonable to put respondents to the trouble and expense of meeting such a point when it isn't in fact a point of substance. The next ground of review concerns the involvement of the Petroleum Agency South Africa, PASA. And the ground is that the Environment Minister unlawfully relied on the appeals as the competent authority in respect of the environmental authorization when in fact it was an interested agency and it wasn't independent of this ground. The first is factual. As my learned friend showed you yesterday, the PASA official who signed the relevant table, which will, as you'll recall, had a third column, the department's speaking. The second is from another department because of the one in environmental system agreement. The idea that those originally involved must not be involved. They must not comment on the grounds of appeal or draw other information relevant to the appeal to the attention of the responsible minister, because that somehow creates an apprehension of bias. Appeal serves for internal appeals to a delegator. Two purposes are served by that. The decision becomes final and doing so avoids the necessity for the courts being troubled with a matter which can be concluded in. The delegator is accountable for the functions of the department, executing its statutory mandate, and particularly in this instance, the actions of officials executing authority delegated to them by the minister. So the minister carries the proverbial can, and the minister is therefore entitled to engage with the department expressed through its political head, the minister. So this is based on a fundamental misconception to the function when it comes to applications for relating to petroleum. It is the agency designated in terms of Section 70 of that Act to perform the functions as comprises Section 69 to 90, the decision maker under the MPRDA, and then importantly for present purposes, calling on the applicant to submit the relevant environmental reports required in terms of Chapter 5 of the NEMA, that is Sections 23 to 24S, and we are dealing with a decision taken under Chapter Acceptance and the conditions of the environmental authorization and amendments thereto. In instances where, as here, the Minerals Minister make these recommendations to the DG, as well as recommendations regarding conditions. Then where there is Regulation 5 of the National Appeal Regulations, which are in our Learned Friends for the States bundle of authorities. It provides parties, and then the important words, and organs of state could submit responding statements. And according to the appeal authority, the Environment Minister in this case, in the present instance, PASA submitted a responding statement in its capacity as a knowledgeable organ of state. I quote, PASA is a government entity and constitutes an organ of state for purposes of the regulations, performing its functions on behalf of the state. Having regard to the functions performed by PASA, which include the review of reports and the making of recommendations regarding their acceptance, its involvement in responding to the appeals was both necessary and consistent with the requirements of the law. We therefore submit that PASA's involvement in the process which culminated in the dismissal. And lastly, we respectfully submit that Judge Manku Lockwood's reasoning when rejecting a similar challenge in Green Connection at paragraph 5 is with respect compelling to what with the 4 sub-components. And it's a failure to consider relevant information, and it pertains to both the DG and the Environment Minister this time. Information in question is that pertaining to the National Environmental Management Integrated Coastal Management Act, 24 of 2008, which we shall call ICMA, need and desirability, supposed deficiencies in the EMPR, and marine and cumulative impacts. Overall, we submit the application that Section 63(1) of the ICMA, which is quoted along with the relevant definitions in Section 1 in our heads at pages 46 to 51. And we emphasize 9 points in this connection. First, in compliance with the EIA Regulations Appendix 1, Sections 3(1) e, the bar expressly identifies the ICMA as, and Milady, the reference to SLB there is to the state's legislation bundle. The bar expressly identifies the ICMA as applicable legislation. And one sees that from page 288, section 4.6. We needn't go there. My learned friend for the state took you there yesterday. As to the applicant's complaint, that the bar doesn't mention that the state is a public trustee or the public trustee of coastal public property, which it is common cause includes South Africa's exclusive economic zone, where the seismic survey will occur. We submit it was entirely reasonable for the authors of the bar to accept that the DG and the Minister understood that under the ICMA, the state is the public trustee of all coastal public property. Just as the bar didn't have to explain to the DG that he was the competent authority, so too it didn't have to explain that the state is the public trustee. Secondly, Section 7 of the bar concludes with a fair-minded description of the competing views regarding at the bottom of the page. One sees a paragraph below the last of the series of bullets. Seismic reconnaissance projects are controversial in South Africa and has been in the news frequently in the last year. For many stakeholders, it's an emotional matter. For others, the potential of impacting their livelihoods is the biggest fear. There are also stakeholders that feel that the exploration for fossil fuels is not in line with sustainable development and the fight against climate change. Other stakeholders feel that it's imperative for the growth and development of the South African economy to engage in these investigations. And that, with respect, fairly encapsulates the debate about this. What one then sees from baseline assessment and a comprehensive assessment of the impacts of the proposed seismic survey activities on the environment, and then the proposed mitigation measures. And it is broken down into granular detail. By doing so, the bar provided the DG and the Environment Minister with the information necessary to ensure that any potentially affected coastal public property is managed, alerted the decision makers to these public goods which are contended for on both sides of the debate before getting stuck into what is the environment, what are the impacts, or will the impacts be, and what are the mitigation measures. Then, my lady, if I could ask you to go to page 294 to 304, which is table 6 of the bar. Rather unfelicitously headed needs and desirability analysis for the proposed. But our point is that the contents of this, which stretches for about 8 pages to 304, if one were to take several pages in our heads of argument, various factors that have to be taken into account, in fact, circumstances, and you compare it with the question to which answers have to be provided, questions and answers. That, in our submissions, covers most of the ICMA section 63.1 factors, just in this table. For example, at page 293, the preceding page, where this table is described, it's described as, and this is under para 5.1 there, my lady, the needs and desirability analysis component of the guideline on need and desirability in terms of the EIA regulations, you were referred to that guideline yesterday, includes but is not limited to describing the linkages and dependencies between human well-being, livelihoods and ecosystem services applicable to the area in question, and how the proposed development's ecological impacts will result in socio-economic impacts, for example on livelihoods, opportunity costs, etc. Table 6 present the needs and desirability analysis undertaken for this project. And what then follows, if one looks at the table itself, is it deals with two overarching themes. The first in paragraph 1 and its subparagraphs is, and I quote, securing ecologically sustainable development and use of natural resources. And the second in paragraph 2 in its subparagraphs is promoting justifiable economic and social development. And your ladyship will immediately recognize the two main countervailing factors, or relevant factors, to which my learned friend Ms. Rajab Badanda for the applicants referred yesterday with reference to section 2 of the principles in section 2 of NEMA there. And it then addresses these themes through approximately 80 questions, sub-questions and categories, each of which has its own detailed answers that in many instances cross-refer to other content in the bar. The issues addressed include ecological integrity, critical biodiversity areas, conservation targets, disturbances to ecosystems, loss of biological diversity, cultural heritage, economic growth, justifiability with reference to intra and generational equity, a precautionary approach, communities' physical, psychological, developmental, cultural and social needs and interests, opportunity costs, environmental justice, equitable access to environmental resources, benefits and services to meet basic human needs and ensure human well-being, job creation, mitigation measures, and the long-term environmental legacy and managed burden. The final question directed to TGS in this schedule was describe the positive and negative cumulative socio-economic impact, bearing in mind the size, scale, scope and nature of the project in relation to its location and other planned developments in the area. TGS answered this question with reference to the comprehensive impact assessment set out in section 9 of the bar, and we therefore submit that in compliance with section 63(1)(h)(7) of the ICMA and section 24 of the Constitution, the bar therefore set out all of the relevant information regarding whether the survey activities are aligned with the interests of the whole community and are socially and economically justifiable and economically sustainable. In other words, in our submission, and this is something which is detailed in our heads of argument at paragraphs 80 to 96 on pages 52 to 60, the requirements of section 63(1) were in fact addressed in comprehensive detail in the bar. And I should mention that that refers to the particular paragraphs and factors as one goes through it. The Environment Minister therefore rightly concluded in her appeal decision, after considering the appeal submissions, that while the DMPRDG decision doesn't explicitly refer to the NEM-ICMA, issues required under section 63 were in fact considered during the assessment and decision-making process. Our fifth point is, as explained in the executive summary of the bar, under the heading Impact Statement, the overall outcome of the assessment is as follows. The findings of the specialist studies conclude that there are no environmental fatal flaws that should prevent the proposed project from proceeding, provided that the recommended mitigation and management measures are implemented. Based on the nature and extent of the proposed project, the level of disturbance predicted as a result of the survey activities, the findings of the specialist studies, and the understanding of the significance understanding of the significance level of potential environmental impacts, it's the opinion of the EIA project team and the EAP that significance levels of majority of the identified impacts can generally be reduced to an acceptable level by implementing the recommended mitigation measures, and the project should be authorized. Sixth, and consequently, it's not surprising that the Environment Minister says in his affidavit that it didn't matter that the bar did not contain, and by the way, that's the current Environment Minister who made the affidavit, that it didn't contain an itemization in accordance with the paragraphs of section 63(1). That is because the contents of the bar just mentioned substantially overlap with the issues that must be considered under the NEMA EIA process. Seventh, both the Environment Minister and the DG have said in their affidavits that both during the DG's decision-making process and during the appeal process, the requirements of the ICMA were considered. In her appeal decision, the then Environment Minister said, "I note that it submitted that there was a failure to consider the relevant coastal management considerations or to comply with this ICMA. I've considered the bar and am satisfied that the provisions of the ICMA and Section 33 were considered." So the applicant's argument really amounts to this. In respect of consideration of Section 63(1) of the ICMA, the Environment Minister has lied under oath in these proceedings. However, for the reasons explained in paragraph 103.1 of our head, such a finding is not lately made in motion proceedings, and it certainly cannot be made in this case. And I pause again there, my lady. You're going to hear me on costs at the end of this matter. And it's not just going to be about nitpicking, and it's not just going to be about jettisoning grounds of review which required an enormous amount of work and time when they were obviously stillborn. Had proper instructions been taken, for instance, it would have been clear that there was no case based on public participation, but reams of paper and hours of work had to be expended in order to deal with that. You're not just going to hear me on that. I submit that when one is faced with substantiated denials of allegations like this, denials by the state respondents now, and nevertheless the argument is persisted with, and it entails a contention necessarily implicit of an allegation of perjury. If the court concludes that that was not reasonable, doing so was not reasonable, that is a factor which it will weigh in the exercise of its discretion. And this is the second problem of that kind to which I have referred during the argument. Then there is the applicant's reliance again on the Green Connection judgment at paragraphs 118 to 126. We emphasize again that the present case is distinguishable because in fact considered during the decision-making process. And further, because the substance of the relevant ICMA factors was assessed and addressed in the bar. Any fair reading of that document will reach that conclusion. If the court finds that it is not distinguishable, then we respectfully submit this court should not follow it for the reasons given in paragraph 104 of our heads of argument, although we do accept that in the circumstances of the full court judgment that is pending in the SCA's key findings. That brings us to the second subground here regarding need and desirability, where the applicants argue in effect that because the main aim of the seismic survey is to locate potentially commercially viable subsea natural gas fields, the bar should have but did not consider the environmental costs and negative impacts of the production of natural gas, and I should really say, and the use specifically of the produced gas. I do add those words at the end of the next paragraph, because it is really the use of the produced gas which has the climate change adverse impacts on which so much emphasis is placed before you. But that's not to say that its production does not also have certain adverse impacts which have to be weighed carefully when deciding whether or not to authorize that. In our submission, this ground of review is based on a fallacy, which is the following. It is And this is the proposition on which it is based. In relation to an application for an environment authorization to conduct a seismic survey aimed at locating possible underground, or in this case undersea sources of natural gas, the potential consequences or impacts on the environment to be considered, assessed and reported on to the competent authority. We say this is fallacious because of what the legislation actually requires. Section 24.1 is the fons et origo of the activities must be considered, investigated. That is then elaborated on in the EIA regulations. Section 3.1 of Appendix 1, which is quoted in our heads at pages 71 to 78, prescribes in detail the scope of it, conformably with Section 24.1, on the activity or proposed activity for which environmental authorization is being sought. The proposed generation of low-frequency, low-energy sound pulses just below the ocean surface, directed at the seabed, as well as picking up and recording for later analysis the resulting acoustic gated and assessed and reported on to the competent authority was the next survey alone. Conformity requires is that the competent authority have regard to the proposed seismic survey one to those regulations, such as the, or I may add, of such 5 further EAs, and who knows what will be found, and who knows what will be found where, hold of them, where, hold of them. One of them might be very deep, others might be very deep, others might. Those are all things anyone, be it an applicant, brings us to the main aim of the seismic survey. Applicant brings us to the main aim of the seismic survey. That also points to the proper focus, whether it is desirable to gather, potentially desirable to gather, potentially commercially viable, so the impugned decisions, commercially viable, so the impugned decisions, component of the Republic's ocean's economy, country including this country's economy, country including this country. But for return, it identified various needs. So for return, it identified various needs so as to contribute to informed policy reference to the relevant parts of the bar, of the climate change impacts which will be caused by burning materially distinguishable, be different, far less intrusive green connection isn't distinguishable. Our heads at pages 82 to 85. MPR of appendix 4 to the EIA and narrowed to a contention that specific wording recommended in the SIA, the social impact assessment, requiring direct engagement by TGS with the fishing communities in mitigation of the lack of a social license to operate. This is a concept which seems to me to have to do with general acceptance from the coastal communities of the benefits of this work being done. That, they say, was admitted from the EMPR. Now, before I deal with the details in that connection, I would just like to make a submission relating to the point which your ladyship raised with my learned friend right at the end of his address. You will recall that you mentioned condition 5.4.3 in the environment authorization, which is at page 200. And to refresh your memory, I'll just read it to you. Should there be changes in the operation and management of the authorized activities, The EMPR must be amended to accommodate those changes and be submitted to the competent authority for approval before implementation commences. Your Ladyship will recall that.
Yes.
May I ask you to go to page 1597, which forms part of the EMPR. At paragraph 10, under the heading, it's headed Review and Revision of the EMPR. So this is now the EMPR which was approved simultaneously with the Environment Authorization, giving effect to that condition too. It says, it is important to note that this EMPR, conditions under which the EMPR would require revision include changes in legislation, occurrence of unanticipated impacts or impacts of greater intensity, extent, and significance than predicted, inadequate mitigation measures, i.e. where environmental performance doesn't meet the required level despite the implementation of the mitigation measure. Secondary impacts occur as a result of the mitigation measures, and instances where the implementation of the specified management as a result of changes in circumstances may become impractical or unreasonable to implement. The applicant, in consultation with the ECO, that's the Environment Control Officer, an official which has to be appointed, independent person, to oversee operations, should be responsible for ensuring that the registration and updating of all relevant EMPR documentation is carried out. There is a condition relating to the ECO. So what this means is that the EMPR is not cast in stone. It has to be complied with, but it can be revised in certain circumstances. And examples are given here. And that's entirely reasonable in the context of a project which is not a one-off. It's not a big bang, this project. It is something which is going to happen in this sort of linear fashion as the boat proceeds along these transepts through the project area over a period of 70 days. And there may well be learnings which require adjustments to be made, bearing in mind always, of course, that they must be consistent with the overall aim of avoiding serious harm to the environment.
Mr. Breitenbach, I see on page 1598, it says the ECO must undertake a risk assessment of any proposed changes to the EMPR. This risk assessment must be included in the applicable monthly audit report. And then it goes on and says, where applicable, supported by the necessary proof of public consultation.
Yes. And the requirement that, of course, any changes are approved by the competent authority, my lady. So this is not a license to change the goalposts. It's the careful, it's just emblematic, and the point I really want to make is that it's emblematic of the fine-grained nature of the permission that was granted to my client and of the careful consideration that has gone into ensuring that the environment is in fact not materially adversely affected by what is intended. Returning then to the applicant's argument. In line with their heads, they have narrowed the particular change or challenge to the EMPR to a contention that, quote, specific wording recommended in the social impact assessment requiring direct engagement by TGS with fishing communities in mitigation of the lack of a social license to operate was omitted from the EMPR. And to substantiate the argument, the applicants have prepared a comparison between the SIA and the EMPR, which is Annexure RA 14 at page 4700, and you'll recall you were taken to that. So this annexure, which is in landscape and takes up 1 and a bit pages. Yes, my lady, if you could take it out. That is the sum total of the applicant's complaints about the EMPR. And the complaint is one that certain specific wording requiring direct engagement by TGS with the fishing communities was omitted. Now the question is that factually correct? And we say it's clear, when has regard to the EMPR, that no SIA measures were omitted, and in some instances the wording was merely changed in the social impact assessment, which is now at page 1465. At the top bullet point you will see a statement by the social impact assessor that a representative from TGS should consult with the traditional leadership of affected communities. You see that, my lady?
I do.
So the question is now, is that recommendation in the EMPR? And could I ask you to go to page 1604? Specifically to section 13.7D. There you have it, my lady. The very same. Turning to the specific wording. So, my lady, this complaint is unfounded. The specific wording which in the SIA, which was not carried through to the EMPR, the wording is, this is an explicit request from community members, and failing to do so will increase the reputational risk for TGS and weakens their social license to operate further. One is consultation. But consultation obligation wording was that's at page 145 line 9, my lady. In the recommendation section of the SI, what one sees in the EMPR, the impacts of seismic surveys, 465 campaign, and noted that having meet 0.7D of the EMPR, the second bullet point, the first sentence of that. TGS should also initiate discussions in their industry. The seismic survey industry should reassess their position and social license to operate as an industry in a South African awareness raising and education campaign under this rubric. And it's that the follow-up and workshops where can address the community's need for education and cooperation for answers. Now these are the only patients was excluded from the EMP. Here argument on it. The next relates to marine and cumulative on the biodiversity and undated in this court. She's an acoustic report. And 5 credit. The Fuene report was finalized just before docs after, as we explain in our heads, and consequently did not succeed by impugning. It's clear what the applicants would have decided, and they disagree with the assessment of content. All those principles are very well established. They disagree with the assessment of content. All those principles are very well established. Bundle. I'll be there in a moment. And His Lordship says the point must be stressed that the function of the court is to vet the challenge decisions and regulations. In that case, it was the regulations made under the Disaster Management Act during the COVID-19 period, made in terms of the DMA for their regularity and not their wisdom. The reason for this was highlighted by Laws J in RV Somerset County Council, ex parte, Fewings and others. The case concerning a review of a decision by a local government to prohibit stag hunting on land owned by it, and which had elicited intense public responses in favour of and against the decision. He said, although judicial review is an area of the law which is increasingly and rightly exposed to a good deal of media publicity, one of its most important characteristics is not, I think, generally very clearly understood. It is that in most cases, the Judicial Review Court is not concerned with the merits of the decision under review. The court doesn't ask itself the question, is this decision right or wrong? Far less does the judge ask himself whether he himself would have arrived at the decision in question. It is, however, of great importance that this should be understood, especially where the subject matter of the case excites fierce controversy, the clash of wholly irreconcilable but deeply held views, an acrimonious but principled debate. In such a case, it is essential that those who espouse either side of the argument should understand beyond any possibility of doubt that the task of the court and the judgment at which it arrives have nothing to do with the question which view is the better one. Otherwise, justice would not be seen to be done. Those who support the losing party might believe that the judge had decided the case as he has because he agrees with their opponents. That would be very damaging to the imperative of public confidence in an impartial court. The only question for the judge is whether the decision taken by the body under review was one which it was legally permitted to take in the way it did. And we commend that passage not just to the court but to ourselves. I hesitate to say to all of our colleagues, because I'm going to criticize them for overstepping the mark, but I do so collegially. During oral argument yesterday, the court inquired as to what should be made of the reams of ex post facto expert evidence that the applicants have put forward in this litigation. The applicants' counsel argued that the evidence demonstrated the supposed gaps in the information before the decision maker, which implicated the precautionary principle, and which required that the environmental authorization be refused. Now, as we demonstrate in our heads in a very long section at pages 88 to 122, paras 132 to 192, each of the supposed gaps in the BAR and the expert reports is illusory or immaterial or amounts to a difference of opinion between the parties' experts. And we note that in their oral argument, the applicants did not even attempt to counter any of those points. In other words, we dealt in detail with each of the 9 supposed gaps in the one, the 5 in the other, and so on. In the circumstances of this case, the expert evidence demonstrates that the precautionary approach did not mandate, in the sense of require, refusal of the environment authorization. Instead, when faced with uncertainty or a lack of information on an issue, the BAR, and I should mention the specialist reports which informed it, assumed the worst case scenario and then modeled the mitigation measures accordingly. Crucially, and this is the real litmus test here, my lady, I've called this a merits review, because what you've been asked to do is to assess whether the reasoning of the decision makers yields, and what they did shows that they acted unreasonably. The essential complaint being, as I understand it, that in granting this authorization on the conditions they did, they acted unreasonably. And if that is the correct way of framing the inquiry, which I believe it is, given the provenance of this court's jurisdiction, section 33(1) of the Constitution, and the provisions of the PADJA derived from it, we make this submission. They did indeed act reasonably in granting the environmental authorization, subject to the extensive mitigation measures which cater, amongst other things, for areas of uncertainty. What the applicant's papers do not do, despite their prolixity, is demonstrate even one instance or a gap or uncertainty which was not addressed in the BAR, the EMPR, or the conditions of approval. If an environment authorization could only be granted on perfect information, very few listed activities would ever be authorized. And that would be antithetical to the Constitution's vision of sustainable development. And that's why, my learned friends, the fact that they couldn't point to any gaps, etc., not addressed in the BAR, the EMPR, was the reason why she was driven to answer in the extreme way that she did. Where there is a gap, many gaps being acknowledged by the experts, you must refuse. It's in the acoustic report and the biodiversity report, and I've given the references. And I intend taking you to some examples to show the applicant's reliance on Dr. Fuene doesn't sustain any recognized ground of judicial review, let alone refute the comprehensive scientific evidence before the decision makers and before this court in the affidavits presented by the relevant experts. Some of the examples show that the supposed gaps are not gaps at all. Others show that the gaps are in reality differences of opinion between the experts. Milady, would it be convenient for me to take the adjournment now, or would you like me to carry on?
Probably it'd be a good time to take it now because you're going to go into the meat of it, aren't you? Thank you very much. Then we'll take the adjournment until 2:15.
Preview was update live. How to test OBS audio without going live.
Is there a setting?
OBS enter the monitor on the option of each audio source in the audio. This allows you to monitor individually.
Is this OBS? Eh?
Yeah, use OBS test audio. So if you go to virtual window,
Thank you, Mr. Bradenberg.
In German, I was going to show you some examples of the applicant's reliance on Dr. Frohnheim, which is supposed gaps which we submit are not gaps at all, or gaps that are in reality differences of opinion between the experts. And in the interest of time, what we're going to do is I'm firstly just going to emphasize that this is dealt with at great length blow by blow, as it were, in the heads of argument, you'll see from page 30, paragraph 85, we deal with a few examples from the acoustic report of Dr. Velata Hernandez. And I'm not going to take you into them for now, for time reasons, but also because they feed into what I'm going to say about the bar in a moment. I do wish to mention, however, what's in paragraph 85.3, because that is not mentioned in the heads. It relates to a point made in oral argument yesterday, criticizing Dr. Velata Hernandez's reliance on a supposedly outdated 2019 report from Southall. She refers to a later 2024 report. We give the reference. But that report, of course, post-dated the acoustic study, which was completed in October 2022, and so couldn't have been reflected in it. And the Dr. Velata Hernandez's sources list shows him taking into account references from 2020, 2021, and 2022 to give the reference. So there's no doubt that this scientist worked with, as he says also in his affidavit, with what was then the up-to-date and current information publicly available. As far as the biodiversity report of Dr. Pulfrich is concerned, we again refer to some examples, but in the interest of time, I'd like to take you to page 32, paragraph 86.2, which is cross-referred to paragraph 154 of our heads. And it's important that, and I'd emphasize this, these experts didn't shy away from gaps in information, but they dealt with them in the way that I've mentioned, in which Dr. Pulfrich outlines in her affidavit, expert affidavit filed in response to the criticisms of her report. So she admits that there were certain information gaps, but she says these were highlighted in the biodiversity report, and the precautionary approach was then followed, pursuant to which sensitive receptors were identified, impacts assessed, assuming the worst case scenario. In addition, as we explained in para 155 of our heads, Dr. Pulfrich points out that seismic surveys have been undertaken off South Africa's coast, not coast, I apologize for the typo, for more than 2 decades, with more than 21 between 2007 and 2021, and no ecosystem-wide effects have to date been attributed to the activities. On the contrary, there's been an increase in whale populations and in their lingering off the west coast, which she says suggests that there aren't long-term negative effects on whale population sizes as a result of the seismic surveys over the past 2 decades. But notwithstanding this, neither Dr. Pulfrich nor the EAP accepted this evidence as conclusive, and instead followed the precautionary approach by recommending mitigation measures, notwithstanding the absence of evidence of harm. And one of those is the 500-meter buffer zone. And that is based on the maximum threshold distance for the noise created by the survey activities. You'll recall that buffer zone says if the passive, basically the acoustic monitors pick up large mammals within 500 meters of the survey vessel, then it automatically stops. And if the marine mammal observers detect any such, whales breaching, etc., then it immediately stops. And that is the accepted way of dealing with this problem. And in a report, if one reads it, it appears, with respect, obvious that she's a fair-minded and reasonable person, sensitive to the things which could go wrong, and suggesting measures aimed at mitigating that risk. mitigating strategies. So in her case, in the case of her report, there were so-called 5 fatal flaws. Dr. Belata Fernandez, he fared worse. As I recall, there were 10 or 11 of them that were identified, worse at the hands of Dr. Furno, that is. But turning to the bar, there was said to be 13 gaps in the bar, and they dealt with by Mr. Whitlow on behalf of the EAP in his affidavit. And we just wish to refer to a couple of them which are of cross-cutting importance. The first in 88.1 is the allegation that the bar failed adequately to assess the cumulative impacts and risks of what the applicants with characteristic verve called seismic blasting relating to other nearby seismic surveys and other nearby exploration and production projects. If we could direct your attention to paragraph 88.3, as we explain in paragraph 181 of our heads, cumulative impacts were considered in detail in section 9 of the bar. I referred to that earlier. It's a very lengthy section, including a section on cumulative impacts. The bar expressly addressed both cumulative impacts in respect of other seismic surveys and in respect of oil and gas development activities in the sort of larger, greater area. And Dr. Pulfrich has confirmed that contrary to the applicant's criticisms, the biodiversity report did assess the cumulative impacts of these multiple projects. They were used to determine a prioritization factor, which the bar then used to determine the overall significance of a particular impact. And so essentially the bar's methodology incorporated cumulative impacts from the outset. As regards the potential cumulative impacts as a result of other surveys, the bar noted that a failure to account for cumulative impacts could lead to the underestimation of impacts. And it again stated that despite the density of seismic surveys over the past 17 years, certain whale populations were increasing, suggesting no evidence of long-term negative effects, certainly on whales as a result of the surveys. Despite impacts on other fauna being unknown, the bar assumed the worst-case scenario of the surveys of three surveys occurring simultaneously, and it then assessed the impact and recommended mitigation measures accordingly. So that is how the precautionary principle was applied in a very practical sense. What did it translate to? A distance of at least 40 kilometers between survey vessels in the event of simultaneous surveys, and that was based on the advice of the American Department of the Interior. And that was adopted out of an abundance of caution. It was larger than what was scientifically justifiable. And in that connection, if I could ask you to note that in the EMPR at page 1609, at paragraph 13.11n, you will see that taken up. Moreover, the bar provides that should there be simultaneous surveys, the EMPR would need to be amended, and that should the 40 kilometer buffer distance be incapable of being maintained, cumulative noise levels will need to be modelled or otherwise considered so as to determine whether any further mitigation measures are required. And one will see that taken up in the EMPR at page 1601, paragraph 13.1c, capital C. Turning to additional exploration and mining activities, not seismic surveys, the bar specifically addressed that too. The cumulative impacts of that, obviously, together with the seismic survey. Dr. Pulfrich has confirmed that it wasn't possible to provide a reliable and conclusive assessment of potential cumulative impacts as a result of other prospecting, mining, exploration and production, but the available evidence suggests that there has been such since 1967 until 2006, and along during that period the populations have increased. But she nevertheless adds that all potential impacts on marine species were identified, a precautionary approach was advocated, and mitigation measures based on the worst case scenario were proposed. As far as what the EP had to say about this, his evidence is that the assessment of cumulative impacts was informed by, amongst other things, very limited and sporadic exploration and production activities having occurred in the recent past, and his view that this trend is unlikely to change. So the prospect of cumulative impacts in question is remote, so it wasn't necessary to deal in detail with cumulative impacts associated with oil and gas activities other than other simultaneous seismic surveys. I suppose one needs to be realistic about this. It's one thing to mobilize a seismic survey vessel. It takes several months, I would imagine, to get everything ready and in order to do the survey for 70 days. Getting going with exploratory drilling and production is an order of magnitude different. So I remind your ladyship that if something unexpected should happen, such as a major oil production activity in the path of the survey vessel being erected, that is the type of thing that the EMPR was designed to deal with, that flexibility in the EMPR that we saw earlier. In paragraph 89, we essentially restate our conclusions on the marine impacts dispute, and I'm not going to repeat what I've already said in introduction now. I'd like to then go to the fourth review ground, which relates to further plans. And your ladyship will recall they relate to two plans: the emergency response and medical evacuation plan, and the shipboard oil pollution emergency plan. Acronyms are ERM, EP, ERMEP, and SOPEP, respectively. The court will recall that the essential complaint is that condition 5.5.6, you may wish to make a note of this, on page 201 of the environmental authorization requires these plans. The complaint being that they weren't to hand at the time when the environmental authorization was granted, and a related complaint being, and there therefore wasn't public participation about them in the run-up to the granting of the authorizations. And they say that that amounts to a breach of section 31H of Appendix 1 to the EIA regulations, in that, so it's alleged the bar and the EMPR failed to identify the impacts and risks of an oil spill, emergency or other emergency incident, and failed to propose mitigation measures in respect thereof, and it didn't address emergency response and medical evacuation. Now, my lady, I'd ask you just to turn to our heads, please, at pages 123 to 125. I'm not going to take you through the detail, but I just want to point out to you how this was dealt with. It's under the heading Further Plans. And you will see at paragraphs 194 to 198, we explain why the applicants are mistaken when they allege that the bar and the EMPR failed to identify the impacts and risks of an oil spill emergency or other emergency incident, and failed to propose mitigation measures. We refer to the relevant sections of the bar in paragraph 194. We refer to the fact that in 195 that the bar required TGS to comply with good international practice in respect to the discharge of waste, and this includes prohibitions on waste disposals in certain locations and a shipboard oil pollution emergency plan. The requirements for that, we point out, are regulated under other legislation, the Marine Pollution Prevention of Pollution from Ships Act, and the regulating agency is another one, the South African Maritime Safety Authority, or SAMSA. And importantly, you will see in relation to the SOPEP that Section 13.17 of the EMPR stipulates the same requirements in relation to the SOPEP, the references given in footnote 458. And we make the point in para 196 that these mitigation measures were included despite the fact that the risk of an emergency like an oil spill is much lower in respect of a seismic survey, where it could only pertain to the survey vessels, in other words, the bunkers used to drive the vessel, than it would be in respect of offshore drilling or hydrocarbon extraction. So both the BAR and the EMPR identified the impacts and risks associated with these emergencies and proposed mitigation measures. Turning to emergency response and medical evacuation, the EA requires TGS to submit such a plan, but they argue that the applicant's argument is the BAR and the EMPR didn't address the ERMEP. But there too they are mistaken. Section 12 of the EMPR expressly addresses the emergency response plan and requires TGS to develop and implement an emergency preparedness and response plan prior to commencing work. And the plan must deal with fire prevention, fire emergency response, spill prevention, spill response, accidents to employees, and the use of hazardous substances and materials. It goes on to detail the spill response procedure and measures to control or remedy any causes of pollution or degradation. Then you can put that away. So it seems that factually, again, the applicants are not off to a flying start. There's then this complaint about public participation in respect of the actual plans themselves. Now, we deal with that in paragraphs 199 to 201, in the same place in our heads, and point out that there was, in fact, public participation in respect of the risk assessments because they were set out in the draft BAR and the draft EMPR put out for public participation. The applicants' real complaint then is that the plans themselves were due to be developed later, rather than they say it's essentially not good enough to set out what the substance of those plans have to cover. Your Ladyship may wish to notice against paragraph 94 of our note that the SAMSA is referred to not just in para 195 but again in para 200 of our heads of argument. And that brings us to Judge Manku-Lockwood's judgment in Green Connection. We agree with our learned friends for the state that that part of the judgment is distinguishable. You will recall that it dealt with two plans which dealing with very serious incidents that happen when one is drilling or producing oil. A blowout contingency plan and an oil spill contingency plan. You'll recall he took you to paragraph 190 of the judgment. The point is, as made by our colleagues, the two plans at issue in Green Connection were plans for dealing with major incidents arising from drilling and production of oil, blowouts and oil spills obviously, which are far removed from the kind of routine safety plans which all vessels have to carry and which are regulated ultimately by SAMSA. And the significance of the regulation by SAMSA is, of course, that it is the specialized agency dealing with safety aboard ships and these matters. And it's quite understandable that in a governmental matrix where you have a specialized agency that should be considered in the sense that you require the plans to be produced, knowing full well that that agency is going to see to it that this particular vessel, and perhaps its support vessels, I suppose must be the support vessels, like all other vessels, has the necessary plans on board by the time you start the survey. And that's the last point that we wish to make, milady. This, by no stretch of the imagination, if this point were good, could it result in a line being drawn through the environmental authorization. We would emphasize, as your ladyship well knows, in Section 8, the governing principle in Section 8.1 of PAJA, when it comes to relief in cases of this kind, for reviewable irregularities, it must be just and equitable. And then certain specifics are given. And that aligns with Section 172(1)(b) of the Constitution. And the just and equitable remedy, if this ground were in one of its other manifestations were found to be good, would be to direct that drafts of these plans must be produced, subject to a public consultation process, and obviously approved before the survey starts. And that then brings us to the issue of relief. And obviously I'm dealing now with the situation where, contrary to everything I've submitted today, this court concludes that the applicants are successful on the merits. And it is well established that in that scenario the court must declare the decisions invalid if the unlawfulness obviously infects both of them, and the authority for that is the well-known All-Pay case in paragraph 25. What does our law say then about the consequence of that? That's dealt with in paragraph 99, and the two authorities we quote there. It follows that TGS's application for an environmental authorization would once again need to be determined by the competent authority. And the reason for that is that the review operates to negative what? It's the decisions by the Minister on the appeals and the DG on the applications. So it would go back to the earliest point in time, which would be the moment before the DG took that decision. And we add that depending on the successful ground or grounds of review, this court may fashion a just and equitable remedy aimed at ensuring that the reviewable irregularity or irregularities is or are not repeated. And in particular, if the court finds that the bar or the EMPR or both of them in their current form are defective, the court acting in terms of Section 8.1(c)(2) of the PAJA, in addition to setting the impugned decisions aside and remitting the matter to the competent authority for reconsideration, could impose directions aimed at ensuring that the defects are corrected before TGS's application for the environmental authorization is redetermined. We would go so far as to say it's obviously a discretionary matter, but it would perhaps be, we would commend it to the court so there can be no uncertainty about what is required. And that, I make that submission because, as your ladyship will appreciate, arguments about the proper interpretation of a judgment down the line are best avoided by a clear direction, do this or don't do that kind. That brings us to the issue of costs.
Before you go there, what do you say about the effect of simply setting the decisions aside?
That is dealt with in paragraph 99. The two authorities that we've quoted say that the effect of that is that the application would need to be redetermined. In other words, fresh decision would have to be taken, because the focus is, such an order would be, what you would cauterize is the decision, which is defective.
But as I tell you why I'm asking this, is that as I understand what was submitted yesterday on behalf of the applicants, remittal isn't sought. We know substitution is no longer sought. Now, if I look at paragraph 99, is that not in effect remittal?
It is, and that's the legal effect.
But this is what I'm struggling to get my head around, because
They don't ask.
they don't ask for it. So what they're asking for now is set the decisions aside.
Yes.
Okay, now what? What happens to the application?
So the answer is provided by those authorities would say the legal consequence is that it would have to be redetermined. But what I do want to emphasize something else.
But is that not remittal?
To alleviate your ladyship's anxiety. I mentioned to you that the power, the remedial power in a case of this kind is discretionary. And authority for that, I don't have the actual paragraphs to hand, it's the TRENCON decision.
Yeah. So you're saying you're saying that given the relief now sought, just so that I understand this, I should then, if I'm with the applicants on one or other or all grounds, I must fashion a remedy under 8.1.
Which is just an
The just and equitable remedy under 8.1 of PAJA.
And that's where one has regard to all the relevant facts and circumstances. The first principle, and the authorities are, they're legion, and your ladyship is doubtless aware of them, is that it must be an effective remedy for the wrong which you have found, or the unlawfulness which you found. So there is a declaration of unlawfulness, and the issue then is anything more than that required? And there are cases, many cases, including at least one judgment of this court, but I hesitate to rely on it because a full bench appeal in that matter is coming up in July, which says that you'd have read that considerations of pragmatism and practicality might militate against that.
It's the whole debate about may or must under the effect of 1721B in parallel.
And that is undoubtedly discretionary. If your ladyship would like, I can give a list, not quite as long as my arm, but very long, supporting that, and I'm happy to do
I just
that.
need, no. I just, may I leave it on the basis that if I'd like it, I can ask for it
Absolutely. I think you may
once
have
all
more than
this
enough
paper has been
information.
returned to my chambers, yes. But just so that I understand this clearly, no just and equitable relief is sought by the applicants either.
That does not absolve you from the...
I understand that. The difficulty that I have is, given the highly technical nature of what we've been dealing with for the past 2 days, am I, as the judge, in a position that is clear to all concerned going forward?
The answer to that, unfortunately, is it depends. It depends on what the particular reviewable irregularity is.
Okay.
And so one of the crucial considerations in fashioning any remedy, and indeed a rule of law requirement, is it must be intelligible, and another is that one mustn't trench. What we say here is that the applicants are hoping somehow, by asking simply for a declaration of invalidity, which of course is mandatory if you find unlawfulness, there is no discretion there,
Yeah.
that's the must part, 172.1a. If you leave it at that, they'll be able to argue that it's back to the draw, motivating the applicant's slimline position now on relief as it has developed. But the thing is that the law says that if you make such a declaration of invalidity, so that the decision is set aside, in effect it's declared invalid, which means that the status quo immediately ante the taking of that decision resuscitates itself. And the only thing which we add is that depending on the grounds of successful review, it may be prudent to direct in your order and not merely to let people interpret it. My last submission, my lady, is this. Submissions on relief, like submissions on costs, by someone in my position are made because your ladyship's order will operate in relation to the world at large, operates in ring. determines the status of something. And because that could have consequences far beyond the parties, in some cases it does do, the courts are given a remedial discretion, and it's obviously difficult for me to deal with every contingency because there are 7, I think, surviving grounds of review if one counts the sub. Hot potato in your hands.
Thank you. I think just an equitable relief I'm just trying to think this through to its logical one or other basis. That just an equitable relief that we're talking about is necessary.
If the relief relates to deficiencies in the bar, variety relating to passes involvement, the decision-making process.
You know how fond I am of acronyms, Mr. Can this court tell your client, when no relief is sought in respect of setting its current application aside, what to do with that application? It's almost like I'm saying, okay, your application stands. Is it open to me, under just and equitable, to say to your client, you must now go away with this no relief in respect of the application itself. Let's call it the antecedent application. Now, is it open to this court to say effectively, because to me, depending on what degree of success there may or may not be and what the review grounds are, but let's talk specifically, just call it the bar, for example, the complaints regulation is there, it's not going to go away.
That's true, and it may be that the client decides not to go ahead with it. So the points that you're making, Milady, with respect, they are relevant factors when it comes to the exercise of bar, or one of the scientific reports on which it was based points would be that the application is not ripe for hearing because there's a gap. Not ripe for determination, and then leave it to my client to decide what to do. But what you could also, subject to the following direction, you mayn't consider it until that gap has been filled. Obviously, your ladyship's discomfort there is that any further than saying that it must fairly balance the competing interests of the parties. But you have an appeal immunity relative. But
I think then one option would be to simply say that it's not right.
On costs.
Sorry, but I interrupted, so I'm also...
So if we stick with the scenario that the applicants succeed in this application, you will see from paragraphs 102 to 105 our submission is the applicants in the state. And the ordinary rule is that the case bears the cost of the litigants who've been successful against it, and there should be no costs orders against any private litigant scenario. In other words, that your ladyship accepts the submissions on the state respondents on our behalf, that none of the applicants' grounds of review has any merit. What should the cost? Has the applicants acted reasonably? Your ladyship has heard me along the way as I've dealt with grounds of review, the grounds of review relating to the two plans. They seek relief which is not consistent with the problem, which is the supposed problem that they identify. The point, our basic submission is they put every way, and many of the points that remain, notwithstanding the costs of two counsel.
Certainly.
My lady, I'm cognizant of the time, and we're at the end of a long 2 days. But there are just a few things that I need to deal with that we cover. The fact that I may not have mentioned all of that during the course of my learned friends, the respondents' arguments yesterday and today, is that there are certainly nuances in the case that we bring to court that the court may want to have reference to in deciding them. That is all set out clearly in our heads of argument, and I have no doubt that the court will be kind of well prepared for that. Let me say at the beginning that, and I said this at the beginning of my previous submission, the applicants are not opposed to development. They're not. They recognize the value of development. But what they're here for is to have a fair and lawful. Holding our public officials accountable is core to our constitutional democracy. It is what distinguishes us from many other countries in the world today. So it's not a frivolous case that we bring to court. It is a very serious thing that these applicants and for their clients. But that is what our law requires. It requires a process that is set out in Rule 53 and in PAJA. And that is the process that the impression is created that this survey activity is an innocuous one, that this is just about data collection. It's about one ship. It's invasive than drilling in the seabed, but it remains an invasive activity. It's not just that the ship is there generally for data collection, ultimately production of oil and gas resources. So this is a commercial and profit-driven operation. And in fact, this is borne out by the fact for a reconnaissance permit. It's a reconnaissance permit for a listed activity. It's a listed activity simply because what they're surveying is oil and gas. This is the context in which this case has been brought to court. And any suggestion otherwise would be wrong as a matter of fact. Then for the third respondent's own note for argument, at paragraph 20, noted harms that the BAR recognizes. And in fact, it's recognized by their own expert, Shrimpton. I'll read you the paragraph, my lady. It says, the scientific fatal injury zone of between 90 meters and 180 meters from the sound source, a zone of temporary hearing loss that is approximately 2.9 kilometers from the sound source. It could, now, those, I stress, are serious harms to our marine life. I said yesterday the sea is not a static, if not thousands of kilometers away. So, where, for example, the third respondent refers to what he calls what they call low frequency energy sound pulses. That's also a term used in the note for argument. Low describe this as follows: air guns, which is how the noise is put out into the sea, produce some of the loudest known underwater sounds on the planet, and in some cases can be detected up to 4,000 kilometers from the source. That's in our founding affidavit. It's not denied in the answering affidavit. And in the acoustic study that's put up, not by the applicants, the acoustic study that's put up in support of TGS's application, at page 1490, I quote, due to the high level of impulsive signal emissions from the array source, marine mammals are predicted to experience a permanent auditory threshold shift at close proximity to the source arrays due to the immediate exposure to individual pulses. A permanent auditory threshold shift. That is permanent damage to marine life that's in close proximity to the source arrays. And they've told us there's no way that they can know with any degree of certainty what marine life is in the area that they're surveying at any given time. They can have lookouts for large-scale mammals, but those are not the only animals at risk. So I say all of this to give context to the argument that's made that this is all very simple and innocuous. Now, if I can then turn to the what my learned friend for the state respondents called, I think, the whale in the sea, or the whale in the water. That is the question.
I think it was the whale in the rock.
The whale in the rock. I'm going to submit that there is no elephant in the room. This is something we've dealt with squarely that we think is legally perfectly answerable and resolvable by this court. That is the question of whether this is an appeal dressed up as a review. In short, it is not. Your ladyship has been cautioned to avoid stepping into the shoes of the decision maker. But we are not asking this court to do that. We've been at pains to explain to the court that we are not asking this court to do that. I have intentionally stayed away from relying on our own experts for that very reason. I took to heart the engagement that I had with the court yesterday. We are not asking the court to make decisions on the merits of this, of the evidence before you. If one looks at our grounds of review, our grounds ask this court to consider what was before a decision maker and whether it was sufficient. We asked the court to consider whether it was appropriate, for example, for the minister to fail to consider a mandatory provision of ICMA. We asked this court to consider whether it was procedurally correct to only consider positive rather than negative factors in a needs and desirability assessment. We don't ask the court to say what those factors may be or that any of them are valid. We ask the court to look at process and whether the decision makers had sufficient information before them when they made their decision. And I stress that when this court considers whether this is in fact an appeal dressed up as a review, that the court consider what in fact the applicant's case is. It's clearly stated in our heads of argument. It has not changed. It's there in black and white. And the fact that this is clear is that even where Paja permits us to seek substitution, because that's an appropriate remedy under Paja, we do not do so. We do not do so in recognition of the fact that to ask this court would do so would require the court to exercise a level of technical understanding of the information before the court that we submit is beyond the scope of this court's powers. So Paja even recognizes that, and that brings me to the law around appeals and reviews. My learned friends have, particularly for the state respondents, sought to make it a simple determination for this court. In fact, it's not a simple question. Our courts have grappled with the question. And that is because Paja introduced it as a substantive element of reasonableness review, effectively. And in fact, Judge Cameron, a judge of appeal as he then was, in Rustenburg Platinum Mines, recognized this when he said, and I quote, in Rustenburg Platinum Mines versus CCMA, which is 2007, volume 1 SA 576 SCA at paragraph 31. He said, in a review, the question is not whether the decision is capable of being justified, but whether the decision maker properly exercised the powers entrusted to him or her. The focus is on the process and on the way in which the decision maker came to a challenged conclusion. This is not to lose sight of the fact that the line between review and appeal is notoriously difficult to draw. This is partly because process-related scrutiny can never blind itself to the substantive merits of the outcome. Indeed, under Paja, the merits to some extent always intrude, since the court must examine the connection between the decision and the reasons the decision maker gives for it, and determine whether the connection is rational. That task can never be performed without taking some account of the substantive merits of the decision. Now, in response to that, my learned friend for the state respondents took the court to the South Durban Community Environmental Alliance case. But that case was different to this. First of all, that case did not overturn this ruling, this particular aspect of the ruling by Cameron J. That remains our law. It's a legal principle, it remains on the books. In any event, in South Durban, the court there was dealing with a material mistake of fact. That is different to the case before this court. And so that court's assessment of whether it was an appeal dressed up as a review is a factual assessment. This court must look at the specific facts of this case, the grounds that have been pleaded, that are before this court, and must make that assessment. We've submitted that our grounds are procedural in nature, and that we've asked the court to consider whether the process followed by the decision makers and the information before them meets the required standards. And if one does this, I would submit that it's very clear that this is a review, plain and simple. Now, if I can then turn on to move on to ground two, our ground two, which has to do with what was in the record before the Director General. This may be one of the grounds that my learned friend for the third respondents calls nitpicking.
Ground two in
Ground
your
two.
heads.
Ground two, yes, it has to do with the information before.
I just want to keep track because ground two in your papers was abandoned.
It's ground two.
So it's ground two of the heads.
Let me just double check, my lady.
Failure to consider EIA
That's correct.
documents. Okay.
That's correct. So page 30 of our.
Thank you.
So as I was saying, my lady, this may be one of the grounds that I'm accused of nitpicking. If that is so, then compliance with the rules and following process is simply a nitpicking exercise. Why bother officials with complying with the rules, with Rule 53, if that is correct? The level of deference that the respondents have asked this court to afford to officials and the executive should we submit be cause for concern. But in any event, this ground is not nitpicking. This is an important ground, which is why the respondents have spent so much time trying to defend it as strongly as they have. Because if the Director General did not have the BAR and the EMPR before him when he made his decision, it does not matter what was in it, because he did not have it. He never had those documents before him when he made his decision.
Ms. Rajab Badlinda, I understand that your client's case is that the complaints are directed at the procedure or the process followed. But can we agree that when it comes to disputes of fact as to what was or wasn't before the decision maker, the state respondent's version must prevail?
If this is a genuine dispute of fact, my lady.
Yes, I mean, but what I'm saying is that the state respondents say we had, the DG said under oath, I had all these things in front of me.
Well, my lady, can I just answer that? The DG does not say that. The minister says that. The minister, that is why this is in fact, I would submit, a good ground of review.
So can I just?
Yes, I apologize.
Sorry, no, it's fine. Because I've also heard, I was also taken to passages in the affidavits where it appeared that something different was said. But leaving that aside, just so that I get we agree on the approach. Let's put it in a different way then. That to the extent that there are disputes of fact, Plascon Evans applies.
Yes.
Even though we're talking about a process attack, if I can put it that way, for purposes of a review. So there's no dispute about. Okay, thank you.
There's no dispute about the fact that Plascon Evans applies in motion proceedings, and these are motion proceedings. In this case, there is no genuine dispute of fact. The DG here, in his affidavit, and I'll take your ladyship to it, the DG does not say, I had the BAR and the EMPR before me. He does not say that on oath. What you have is an environmental authorization which refers to those documents. And then what you have is a minister saying, in fact, then what you have is the minister inferring from an environmental authorization that the DG had these things before him when he took his decision. So I'm going to say that again. What we have is we have an affidavit before this court that is, bear with me, at page 3996. That's the DG's, 3995 is the first page of the DG's affidavit. It is not simply a confirmatory affidavit. It is a 26-page affidavit which goes through at length the legislative history and policy framework and the One Environment system. And then in one paragraph, at paragraph 2.4 at page 3997, it says, the DG says, I therefore repeat and incorporate the contents of the second respondent's answering affidavit and confirm its correctness insofar as it refers and pertains to the DMPR, me and my decision of 17 April 2023. Now, what's important here is that what he doesn't say in this affidavit. He says, I possess control, familiar with, have verified the DMPRs, that's the Mineral Resources Department's official records, policies, reports, guidelines, and other documentation available. But he does not say what I had before me in this application. He says, I looked at the founding affidavit. I read the founding affidavit. The founding affidavit squarely raises this ground that questions what he had before him. And he chooses not to say, these are all the things I had before me, including the BAR and the EMPR. So you have that affidavit. That's on oath. Then you have an environmental authorization, which is not an affidavit. You have an environmental authorization in terms of which the DG refers to the existence of the BAR and the ENPR. That's number 2. Number 3, what you have is an affidavit by the minister inferring that the DG had the things that he refers to in his environmental authorization before him at the time he took the decision. There is no way that the minister, it's hearsay, the minister doesn't know what the DG did or didn't have. But to compound all of that, we then have a Rule 53 record placed before the court. Rule 53 is the process through which PAJA is given effect to in this court. We have a Rule 53 record which is required to be a complete, be a complete record of what was before the decision maker when he took his decision. That Rule 53 record only has the third respondent's application. It does not have any of these specialist studies. It doesn't have the BAR or the NPR. And we have correspondence between my attorneys, the applicant's attorneys, and the DG's attorneys, the state attorney. And I'd just like to find the relevant page number. If I can refer the court to page 2476, and it runs till page 2488. I just want to go there, if you bear with me. Have you found it, my lady? It's
2476.
2476 is the first page. What you see there is a series of letters between my attorney, Reynolds Albertine, and the state attorney. And I'm not going to take the court through each one of those letters, but the import of the letters is the same. We keep writing to the state attorney saying, can you please confirm which part of the record served before the DG and which part served before the minister? And then if you look at page 2478, paragraph 2 of that letter says, please confirm that the record delivered to us on 4 March 2025 constitutes the full record. If you keep reading, there's a third letter, page 2480, where again the applicant's attorneys ask that question. Please in the circumstances, just find the right spot. Effectively, it says, please confirm which part of the record served before the first respondent and which part of the record served before the second respondent. It is imperative that we know what documents served before each of the first and second respondents. And if one keeps paging through, another letter at page 2483. Again, same questions are asked. And finally...
Sorry, may I just ask, at page 2485.
2485, yes, that's where I'm going now.
JWS3C.
Yes.
Herewith the link to the record which served before the first respondent.
Yes.
Where do I find that in hard copy?
That is the record. I'll find you the exact reference.
Because the first
It's not in the
respondent is
paginated
the DG. It says here with the link of the record which served before the first respondent, and then here with the link of the record which served for the second respondent. The above documents are placed in separate folders, and the flash drive provided by your office in each record has its own separate index. Is that what was the index was drafted from, what was provided? Okay.
Yes. The important thing about this letter, my lady, is that the state attorney who finally responds to our correspondence from 2012 and 7 March responds on the 7th of April and says, here's the link of the record which served before the second respondent, and I'm just finding the relevant bit, if you just bear with me. Just just want to find you the right.
Yes, in the
reference.
affidavit itself.
No, there is a letter that says that the. Just bear with me. Yes, so in the letter of 7th April, the State Attorney confirms that this is the complete Rule 53 record and the link to what was before the first responder. Okay. So, there is a difficulty with the respondents arguing before this court that if the record is deficient, well, that's just a problem with the record, and that's not so important, which is the gist of the state respondent's case in relation to the mistakes in the record. What's missing from the record, they say, is, well, that just means the record is deficient, and you must ignore that deficiency and simply rely on the say-so of the DG. But of course, we don't have the say-so of the DG because he doesn't say on the answering affidavit, in his answering affidavit, exactly what was before him. So we would stress that this Director General had ample opportunity to answer this ground of review properly and to file a complete record. His State Attorney confirms that it's a complete record that has been given to us. If we accept that as so, as we're entitled to do, then the record does not have the BAR and the EMPR and any other specialist reports.
You see, I think this is possibly, and I'm sorry, I know it's in reply, but I think this is where I'm getting a bit confused about this Rule 53 record.
Yes.
Because if we start at page, okay, we've dealt with JW3C. If we go to page 2448.
Yes. Two double 4 8.
Yes. It starts with paragraph 17.
Yes.
Do you have it there? Oh,
Yes,
okay.
I have it.
Sorry, I was just waiting for you.
Yes, thank you.
Okay, so if we go back one paragraph, JWS3C arrives,
Yes.
and then, as the applicant's attorney pointed out to the State Attorney, an email replied the next day, this was not correct. The reply stated that, firstly, only one record had been delivered to the applicant's attorney on a flash drive. The one I've referred to about purporting to be the record of the first and second respondents. Secondly, what purported to be a link in the State Attorney's email of the 7th of April to the first respondent's record was not able to be opened. And thirdly, since the applicants were unable to ascertain which part of the record received relates to which respondent, they needed an extension of time for their supplementary pay.
Now, I took the court to the paragraph in the DG's affidavit where he confirms the correctness of what's contained in the minister's affidavit. We submit that that is not sufficient in any event. That the question of confirmatory affidavits, and I have submitted, this is not simply a confirmatory affidavit, this was an opportunity where the DG, which the DG took to place 26 pages before the court. And in one paragraph, he confirmed the minister's affidavit. But this process of confirming something that is said in another person's affidavit has been the subject of some debate in our courts. In Khalil, the SCA held, and Khalil is Khalil, K-A-L-I-L, versus Mangaung Metropolitan Municipality and others, 2014, Volume 5, SA 123, SCA. In Khalil, the SCA said, confirmatory affidavits at time may have their place, but by and large constitute a slothful means of placing evidence before a court. which is entitled to expect that the actual witness to an event depose to the facts. And then relying on this dicta in Khalil, the Eastern Cape High Court, in a case called Blue Crane Municipality versus Storm, in fact, I haven't referred to this in my head, so if your ladyship would like copies of it, I'm happy to.
Roger, but in the high courts don't rely on SCO authority, they're bound by SCO authority.
There you go. In a case of the Eastern Cape High Court, the Eastern Cape High Court relied on the SCA and said, and dismissed the applicant's reliance on confirmatory affidavits because the deponents to those affidavits merely stated that they confirmed the replying affidavit, quote, insofar as it pertained to them. And the court there held that if they are to carry weight, they must provide personal observations or factual detail, and they cannot simply rubber stamp what is said in another affidavit. And that's at paragraph 24 of Blue Crane. And then finally, in response to that, the third respondent argues that Pambili Fisheries, which is, of course, the quota quo that ultimately ended up in, I think, Beta-Star in the Constitutional Court. The third respondent said that Pambili Fisheries in the High Court disposed of that matter because, or I think, in fact, I may be wrong on that. They may have referred to the SCA judgment. I'll just double check that. But they said Pambili Fisheries disposed of the matter because there the SCA held that a confirmatory affidavit in that case was sufficient. But that case is actually different to ours because if one looks at Pambili at paragraph 20, and it is an SCA judgment, so I'll correct myself, at paragraph 20, the deponent to a confirmatory affidavit had supplied a supplementary affidavit specifying facts that he'd confirmed. So it wasn't just a confirmatory affidavit, one affidavit as we have in this case, it was two. It was a supplementary affidavit that specified facts, specifically that he'd confirmed. So it's Pambili is different to our case, is the short argument. Our court is asked how the DG could possibly have not had those reports before him if he referred to it in his environmental authorization. Well, the short answer is it's clear from the papers that it's not the DG that drafts the environmental authorization, it's PASA. PASA did that. We know that because these allegations in our founding and supplementary affidavits were not denied, but also because the inquiry's point person is listed on the top of the environmental authorization as an official of PASA. In fact, my learned friend for the state respondents went so far as to describe PASA as part of the department. I'm not going to associate or align myself with that submission. I think it's wrong as a matter of law. But in any event, what's clear is that PASA drafts the environmental authorization and the DG is meant to consider and sign it. But he's not just allowed to tick box and sign. He actually has to look and inquire and apply his mind to the information that forms the substance of that environmental authorization. Otherwise, it renders that process completely meaningless. So if one says, well, why did the DG refer to the BAR? The DG didn't. PASA did. The DG signed it. And that we would submit as a probable answer when one looks at the existence of an incomplete record, the lack of a confirmation properly on affidavit by the DG, and an environmental authorization at odds with those things. All right, I think I've said enough on the record, my lady. I'll end simply by saying how this court decides this ground of review is important for what our courts say about the importance of a Rule 53 record. And so it is not, these are not submissions that we make lightly. My lady, you were told today, my lady, that that a finding that you would have to make in order to find with the respondents on this ground, particularly in relation to the record, sorry, I said I was finished, but I have one more issue, is that you would have to find the minister guilty of perjury. Now, that's just not right. That's just not true. This court does not, that is a scare tactic with all due respect to my colleagues. This court does not, we have not asked this court to say that the minister lied under oath. In fact, we have been at pains to say that the minister did not say the DG had these documents before him. The minister makes that inference based on the environmental authorization. So there's no need for this court to make a finding of perjury against the minister. We do not say the minister lied. The problem here lies with the DG, not with the minister. And if I can stress once more, the ground of review here relates to the fact that the DG did not have the relevant information before him at the time that he took his decision. That is the ground of review. That is a reviewable irregularity. Then if I can move briefly to ICMA. To clarify, our ground of review based on ICMA relates to the fact that the minister did not consider properly or at all the grounds in section 63 of ICMA. I just clarify that because in my learned friend for the state respondents address, he referred to the fact that we had in our oral argument referred to 2 grounds, I think he said. The position is that we stand by everything in our heads of argument. Our submission is that the minister did not consider any of the grounds in section 63, not just 2 grounds. The second submission he made in relation to ICMA was, actually it's not clear that ICMA even applies, if I understand the submission correctly, because the activity in this case doesn't form part of coastal activities. Well, my lady, if you just bear with me, I'm going to just pull up the statutes. Coastal activities in ICMA is defined as meaning activities listed or specified in terms of Chapter 5 of NEMA, which take place A, in the coastal zone, B, outside the coastal zone, but have or are likely to have a direct impact on the coastal zone. So what is the coastal zone? One then goes to the definition of coastal zone in section 1 of ICMA, and that is defined to mean the area comprising coastal public property, the coastal protection zone, coastal access land, coastal protected areas, the seashore, and coastal waters, and includes any aspect of the environment on, in, under, or above such area. So the seashore and coastal waters are included in the definition, ultimately, of coastal activities. And that must necessarily include the exclusive economic zone, something which my learned friend for the third respondent appeared to accept in his argument this afternoon. Once that is so, the Act, ICMA, clearly applies to our case, and therefore Section 63 is mandatory for the minister to have considered. It's not sufficient for her simply to say, I considered it and I don't think it applies. She actually has to go through the factors in Section 63, because the language of Section 63, the language used is must. It's a mandatory process that she must go through. Then on the question of needs and desirability, the question the court asked my learned friend yesterday was whether my learned friend was aware of anything that should have been considered as a negative assessment that wasn't. First of all, the ground of review is that it is not about what specific negative ground ought to have been considered. The ground of review is that in conducting a needs and desirability assessment, it mustn't be asymmetric. Such an assessment must be a balanced one that looks both at positive and at negative factors, which was not done in this case. So in this case, all that was done was to look at positive factors of oil and gas exploration, and the needs and desirability assessment goes further than just surveying. It deals also with exploration and production. So that's the nub of our complaint. It's about the asymmetry between positive and negative. If we had to come up with an example of a possible negative that could have been contemplated, then I would imagine it's something like the risk of blowouts during possible future exploration.
No, I didn't mean to convey that I wanted anybody to speculate, but inherent in the argument is that negative and positive had to be balanced. Now, I've heard what the respondents have to say. On the face of it, the BAR took into account.
No, sorry.
From what I've been shown, potential negative factors, and I would appreciate it if you could maybe assist me there. Are you saying that what was considered to be a negative or negative factors in the BAR are not in fact negative factors, but positive factors or neutral factors? I just need to understand that.
Sure. Yes,
So
let
it is a
me
bit late in
clarify.
the day, so I apologize.
No, it is,
if
and
I'm-
it's an incredibly dense case.
Yeah, so I just, that would assist me.
Yes. This grant of review is not related to the BAR generally. It is about the needs and desirability assessment. And that is really an assessment.
The
of-
other acronym.
No, it's not even that.
Not even one of the
Not even-
others.
Not the EMPR. It's specifically the need and desirability assessment. And that is really an assessment to see whether this activity, whether there is a need and desirability for this activity. We say, when you do that, in order to work out whether there is in fact this need or desirability, one has to look at both positive and negative.
Yes.
One can't just look at positives and say, yes, there's a need for oil and gas exploration because the economy requires that. We've heard today about government policy on oil and gas reserves. It's not sufficient. To do that simply gives one part of the picture. If you're doing a genuine assessment of whether something is needed and desirable, we say what should happen is there should be an assessment of all impacts, positive and negative. Yes, the economy is important. Yes, we want to get oil and gas reserve, but also here are some risks that we may need to consider. And then when the minister considers all of this, she has this overall very balanced picture of whether or not there is genuinely a need for this activity to happen. But if you have this asymmetrical approach of only looking at the positives, then what you're presenting the minister or the decision maker with is only one piece of the picture. Now, that's our ground of review. It's not to do with what was in the BAR, which we accept there are many expert reports that also identify certain gaps, and whether that's sufficient or not, that's another issue. This ground of review relates specifically to need and desirability assessment.
By whom?
By independent practitioners who did it on behalf of the applicant and ultimately which formed part of the documents before decision.
But then we're going and then we're coming back.
It's not
Then we're coming back to where we were yesterday. Am I not bound by what's before, but was before or not before, on your argument, the decision makers. So it's one thing for the applicants to say, based on expert reports which post-dated the minister's decision, and obviously the DG's decision, those two decision makers should have taken these other need and desirability factors into account. What I'm trying to do, I suppose, in a sense, is pin you down, if I may. Show me in your papers, your client's papers, where they say what should have been considered at the time it was before the DG and then before the minister, because otherwise, what do I get to work with? You know, I can't just assume, well, this might be a negative factor. So that was really the context in which I was asking Mr. Dupré the question, post facto evidence, but evidence that was before them, or evidence, factors, maybe is a better way to put it, that were drawn to their attention and which were effectively ignored.
Yes.
That I think that would help me. So if you could just, I know it's late, but
my difficulty with that is that's not the ground of review. We're not asking this court, and that's what I am perhaps not explaining well enough. We're not asking this court to say the DG did not take this negative factor into account when looking at the needs and desirability. In fact, let me rephrase that to be clear. We're not asking this court to say, when the DG looked at the needs and desirability report, when that report was completed by an expert, right, so that whether there are any negative factors. So it only looks at what's good about it.
so okay, I get it.
And-
I understand now. So I must read that report
Yeah.
to see whether what is contained in that report only identifies positive factors.
Yes. And if that is so, then we say that is a reviewable irregularity. That report was flawed. it needed to have also the negatives. But I'm not asking this court to weigh in on what those factors would be.
So just taking that a step further, just so that
Yes.
I get it. But the DG and the minister were not slavishly bound by what was contained in a report. They nonetheless had to exercise their own minds independently.
Absolutely.
And they are officials who know about these things.
Yes, there are officials in the Department of Minerals and Environment.
Okay.
No.
I must also look at other things, such as the BAR. Okay, thank you.
Okay. Let me then turn to relief, my lady. I listened closely to the debate that the court
Give me
had.
one sec just to make a note
Yes,
of
yes,
this.
sorry.
Thank you.
Yes.
Thank you.
Yes, thank you, my lady. I listened carefully to the engagement between the court chief. Let me say this. I agree with my learned friend. I think it's correct that if the decisions are reviewed and set aside, that the effect of that is that TGS's application remain. It would be open to TGS to decide whether to pursue that application, as my learned friend indicated. It would be also open to TGS to attempt to do something else with that, such as supplement it and reapply differently. But in the interest of certainty, so from our perspective, part of the reason for not seeking anything other than the review and setting aside is because it all depends on how this court decides this judgment, how the court decides this application. But in the interest of certainty, we submit that the court could make, if the court is with us on one or more grounds, all that is required is for the court to find, if the court is with us on one or more of the grounds, then we submit that the court could make an order similar to that in the Green Connection matter. And that would be the simplest way of exercising the court's discretion. I didn't go into the fact that the court must fashion a just and equitable remedy. I think the court is aware of that power. Is the court could make an order something like this. The decision of the DG dated 17 April 2023 to grant environmental authorization is reviewed and set aside. The decision of the minister dated 22 May 2024 to dismiss the appeals by the applicants against the DG's decision is reviewed and set aside. The decision as to whether to grant the third respondent's application for environmental authorization is remitted to the first respondent, the DG, for reconsideration. And then two subparagraphs. The third respondent must be public participation process must be held in respect of the new or amended assessments as required.
And is that in the
That's
format
all
that was in Green Connection?
It's all in Green Connection,
Right.
yes.
Thank you.
And that we submit would give sufficient certainty without stepping on the toes of any other decision maker or party. The fact that costs should be ordered against the applicants if we are unsuccessful. A lot has been said to attack the papers that were filed by the applicant, the bona fides of the applicants in coming to court, and how our case amounts to nothing of any merit. But it is notable that both sets of respondents have taken all of these pages and many hours of the court's time going through the merits of the case that they say is entirely without merit, and that they've argued them substantively. I would submit this is clearly not a reckless case. This is not other people to appeal the decision of the DG, including, as I said at the beginning of my submissions, the Western Cape Department of Environment. So this is not a frivolity. The principle in BioWatch that the court should make a costs order vexatious or otherwise manifestly inappropriate. That's the language of BioWatch. So you'd have to find that our application is frivolous, vexatious, or otherwise manifestly inappropriate. It's a very high standard, intentionally so, we submit, and that is because of the chilling effect of adverse costs also reflected in NEMA itself, in section 32.2 of NEMA, which provides that a court may decide not to award costs against a person who fails to secure the relief sought. If the fails to secure the relief sought in respect of any breach or threatened breach of any provision of NEMA or any other provision of a specific environmental act, if the court is of the opinion that the person or group of persons acted reasonably out of concern for the public interest or in the interest of protecting the environment and had made due efforts that litigants are able to come to court to assert an environmental right. The fact that NEMA, a statute, bears this provision is highly unusual. And it is saying that for you to order costs, for this court to order costs against the applicants, the court would have to show that the applicants acted unreasonably with no concern for the public interest or in protecting the environment. We submit there is simply no basis to do that. In Silvermine Valley, a case where Judge of the Cape High Court, where Judge Davis presided, he exercised the discretion afforded by this provision of NEMA, section 32.2, and he said as follows, quote, "The fact, however, remains that the applicant had acted in the public interest in terms of a reasonable interpretation of the regulations, and furthermore, after failure on the part of the authorities to protect the pressure, the court should not exercise its discretion insofar as costs are concerned. In further support of this particular conclusion, it seems to me that NGOs should not have unnecessary obstacles placed in their way when they act in a manner designed to hold the state and indeed the private community accountable to the court."
You have the reference for me.
Coalition versus Sybrand, Sybrand, Van der Spey, Boerdery, and others, 2002, Volume 1, SA 478. We would submit that abandoning grounds of review, as we have, does not prejudice the respondents. The complaint before the court was that the respondents to the state in doing that. But if this court sets a precedent that punitive costs, or that costs must flow from an applicant deciding to pursue those grounds which it believes to be legally defend merit. In this case, I could have argued the delegation point, for example, and that would have taken at least another 3 hours of this court's time. I did not do that because in the heads of argument for the third respondent, the argument was made that we ought to do that, but in doing that, I made absolutely clear to the court that we stood by the legal basis for that ground. We stood by the fact that we consider that the provisions that the state respondents say they relied on in giving a delegation to the DG were not correct.
Perspective of your client's view on the merits of that ground. But I mean, that's a tangential issue as far as I'm concerned.
The point is simply this. If you want to respond to the arguments placed before the court, one should not be encouraging litigants to argue or counsel to argue points that they do not believe are legally defensible.
The respondents that anything is directed at you. The applicant should have thought about the merits of their case on all these different grounds before they launched the application, number one. And number two, persisted with certain of those grounds right up until the replying affidavit was filed. I certainly did not understand it to be directed at you.
No, I don't mean to suggest that it was, and I certainly do not take it that there was, that responsible litigants would not have done this, would not have abandoned the applicants. We submit that what the applicants have done in this case is to put as good a case as they possibly could have put before the court, but also then to have considered the responses of the respondent and persisted with grounds in the face shouldn't warrant on litigants such as the applicant. Something that, and in the language of Section 32 of NEMA, we have not acted unreasonably with no concern for the relief that we seek, should review and set aside both decisions, and that an appropriate order would be along the lines of the brief.
Sorry, Mr. Bradley.
Lady, I'm sorry to do this. There are two matters that I'm instructed to bring to your attention arising from the reply, if I may.
Just bear with. Okay, that's fine. Thank you.
First is that my learned friend quoted from paragraph 40 of the founding affidavit. That was the paragraph in which it was alleged that air guns produce some of the loudest is in fact denied at page 3450 in paragraph 324.
Sorry, just hold on a moment. Page
3450,
para.
324 of Mr. Shrimpton's affidavit.
Okay.
And the second concerns Justice Council reviews being sometimes difficult in Seduma. And one must rather then look to the judgments of the Constitutional Court, and that would be Judge Navs's judgment acting at paragraph 109 on that topic.
Is that Sedumo?
That's in Seduma.
Para 109.
109 NAFSA AJ, and then the judgment of Justice Noble in paragraph 244. It doesn't detract from the gist of the point, but unfortunately the ratio decadenti in that saga is to be found in the higher court's judgment relating. I'm indebted to you.
Anybody want to add anything? Before we adjourn, I'd just like to convey my appreciation to all concerned. Obviously, I'm going to need time to digest this, but I really appreciate the assistance that's been given to me and the manner in which the proceedings have been conducted. There is just one aspect that I need to just discuss briefly with you. There is the full court of first instance application in respect to which judgment is pending. You may or may not be aware, you probably are, that a couple of months ago the Supreme Court of Appeal handed down a judgment in which they dealt with let's call it the horizontal application. I, sitting as a single judge as a court of first instance, am bound by a full court's fine, familiar with the ins and outs of that case at all. But to the extent that there may be overlap, or there is some overlap, I think Mr. Dupree mentioned it yesterday, and I'm not going to pretend that I can recall right now. It's just going to, mentioning this to you, is that it may cause me to, because I am then, as I understand it now, bound by what they say. Obviously that's subject to higher appeal processes, but horizontally within this division. So I will reserve judgment today, but there may be a delay as a result of that. I can't obviously ask my colleagues to get a move on. They will be getting a move on, I'm sure, as best they can already. Thank you very much. Court adjourns.